Chief Justice Marshall, members of the Court, good morning. My name is Joseph Piropan, Assistant District Attorney for the Berkshire District, and my argument please this Court. It is the Commonwealth's position instantly that the trial judge committed error by ruling that the school officials from a private parochial school were subjected to the same Fourth Amendment strictures as would public school officials be, acting as they did in the course of a field trip to a ski resort in March of 2003. The essence of the Commonwealth's argument simply is this. If the district court judge's order were upheld, it would represent a sea change in jurisprudence, namely that stemming from the Federal Supreme Court's decision in 1985 in TLO that restricted school searches to reasonable suspicion. That restriction applied only to public school officials.
So, counsel, but you had two schools that took a field trip to go to ski, one public school and one private school, and you had the same facts for both schools. One could search with a reasonable basis and the other couldn't. Same facts, but based on which school we were looking at, you'd have a different standard.
I would respectfully say not, Your Honor, for this reason. If the search were conducted instantly in the setting of a school field trip to a ski resort, then I would suggest that the Supreme Court's decision in Vernonia, which allowed, under an in loco parentis standard, the drug testing of athletes in public schools to apply because of the heightened requirement for safety and monitoring in school athletes. Likewise, the Commonwealth would suggest that if outside of the school, at a ski resort, both public school officials and private school officials would be acting more akin to in loco parentis than as to school officials inside a school.
And what you mean by that is that you do not have to have reasonable suspicion to conduct searches. The Constitution simply doesn't apply. Is that your position?
That would be the Commonwealth's position, Your Honor.
Well, wait a minute. Where's the state action here? In this case, you just said no to. The Commonwealth in the Supreme Court case, it's a public school, but they were saying there's clearly state action, but you've got an in loco parentis doctrine that overlays that. Where's the state action here?
There is no state action here, Your Honor.
So why are we here?
Because the judge made a mistake.
But then your answer to Justice Island's question is it makes a big difference if it's a private school or it's a public school. If it's a public school, there's state action.
If it's a public school, as TLO points out, there would be state action because
Correct.
Public school officials are state actors. Unlike parochial school or private school officials, which we have instantly here, they are not state actors.
Right, but your position in answer to Justice Ireland's question was in the context of a field trip.
That's correct.
And you say even in a field trip situation, if I may finish, and you say even in a field trip situation, if it's a public school, the doctrine of in loco parentis controls, not the Constitution.
And if I may expand on
But
that.
that's not this case.
That's not this case.
That's not this case.
But that was your answer to Justice
That was
Ireland.
my answer, and I want to explain that because I think Justice Marshall has asked a good question. The reason why I responded to Justice Corey in that fashion was simply this. The need for added restrictions in field trips, especially to ski slopes, is that we don't want to have students under the influence of alcohol or tobacco or drugs skiing recklessly down the mountain. So the in loco parentis interest is greater when there is an activity such as skiing, which involves personal and public safety.
But we don't have to worry about that here.
We don't have to worry about that here because we have private school teachers, not public school officials.
Mr. Piropan, what difference does it make that unlike private school, let's say after-study programs, that you have compulsory education here for the state action analysis?
Well, I think that was answered quite specifically in Vernonia, which the court said that education is not the exclusive province of the state. Parents can elect to have their children educated by private individuals, in this case, the Archdiocese of Bristol, or
even at home.
Or even at home. We certainly would not extend TLO to the home setting.
Well, may I ask this, just hypothetically? Let's say no field trip. We're just one public school, private school, at the school. Same standard for both or a different one?
At the school, Your Honor?
Yeah.
Different standard, because
And what's the standard at the private school?
no state
No
action,
standard? No. What do they need to search?
nothing.
Not so they can search whenever they feel like it.
Absolutely.
On a hunch, on a whim, on a guess.
Just because it sounded like a good idea. And essentially, that is the Commonwealth's position. I don't mean to be flip about it, Your Honor, but we have to be ever mindful of the dichotomy between state action and non-state action.
But that's not so unusual. We have that all the time. It's not just in public schools. That there is a dichotomy between state action and non-state action.
Absolutely.
What was in the school manual about possible searches? Wasn't there something in there? I
Yes.
thought it was confined to lockers.
There was, Your Honor. In fact, on the Commonwealth's Record Appendix at page 78, there is I'm sorry. I think it's on page 73. Thank you.
Well, that's all right if you can't remember it.
There was a specific provision regarding the lockers, Your Honor.
But that's a contract claim between the school and the parent and the child.
Yeah, but this wasn't a locker situation, so that really doesn't apply.
Well-
This was a hotel room, as I
It
recall.
was a hotel room at the ski resort. It was a place
And then
of lodging.
eventually they got into certain
But more-
paraphernalia.
But the court raises a good analogy here because the school rules were applicable to field trips as well as to in-school behavior. The school rules specifically forbade alcohol, tobacco, narcotics, and et cetera, and specifically gave the authorities the right to search lockers.
I mean, you got a lot of different rationales here that you can rely on, that this, in effect was a extension of the manual, so they could do it under that local parentis could be used. But the state action seems to me to be the most telling. There's absolutely no state action here.
That is the Commonwealth's essential claim.
Mr. Pierpont, that is why I asked you the question, because your brief was slightly not misleading. I misunderstood your argument because you keep talking about the private citizens acting in loco parentis. I don't care in what capacity they're acting. If there's no state action, it's no state action. If there is state action, then it may be that under the Supreme Court's holding with respect to the athletes that you're in loco parentis and therefore you're still okay. Right? But,
That was your point.
but if there's no state action, it doesn't matter whether they're in loco parentis or not.
Absolutely, Your Honor.
It just means no state action.
The reason why the Commonwealth was making reference to in loco parentis is because in the district court's decisions cited by the district court,
Right.
there was reliance upon a line of cases from the state of New York, which in 1975 did not draw a distinction between public schools and private schools for the purposes of state action. Commonwealth's position simply is that is incorrect, as was shown by TLO, and furthermore was shown by Vernonia. And furthermore, that same appellate court in New York, 3 months after that decision, disowned that dicta.
Well, let's talk about state action. There is state action here at some point, is there not?
No.
The police are called.
They're called.
They come to the, excuse me, they
I'm
come
sorry.
to the hotel, do they not?
Yes.
They are then invited into the room of the student. Is that correct?
Actually, initially, they go into a common room, I believe.
Right. And how do they get permission to have access into the student's room, a room that they personally paid for and in which they surely have an expectation of privacy vis-a-vis the police?
Commonwealth's position is, Your Honor, by the time the police arrive, the school chaperones had not only searched the room,
Yes?
seized the narcotics, and removed them from the room.
No, they hadn't.
They had not.
Weren't they right in the room?
I
They
believe-
were right in the room.
Okay.
The school officials were in the room, the juveniles or the students were in the
I
room.
stand
The police
corrected.
came and the school official said, come on into the room.
I stand
There was
corrected.
no consent given by the students. It was their expectation of privacy. It was their room, was it not?
I disagree with that, Your Honor.
For purposes of constitutional analysis, wasn't it their rule?
No, I disagree with that, because for two reasons. Number one, again, this was a school field trip. That room was restricted by the school rules. The students didn't even have access to that room between the hours of 8:30 in the morning until 10 o'clock at night.
Well, they were required to turn their keys in
That's correct.
so that they couldn't get access.
That's correct.
That's hardly consent by the students to a police search of their room.
But the police did not search the room, Your Honor. The police arrived only after the
The evidence,
chaperones.
the drugs had already been seized, right?
Correct.
So there's really nothing that prevents a private actor from turning over contraband to the police once it's been seized, if the private actor can properly seize it.
That would be the case here.
That
Your
doesn't
Honor, yes.
somehow convert everything into state action.
Mr. Pearlpan, is this record adequate for us to decide? I'm a private party, right? Is this adequate for us to decide? Because I don't think the judge has listed who had control over that rule. In other words, there's no state action for what the school did, right? But if the police arrive at a boarding house or a B&B because the owner, who clearly has access to it, thinks that there's something fishy there, right? We've got a long line of cases that tells the police when they can and cannot get access to a room. Was that argued below?
It was argued only in the analogies to hotel rooms, in the Stoner case from California, in which there was, we clearly give guests in a hotel an expectation of privacy. However, we do not shield them from the actions of private parties, chambermaids and the like. Here is the Commonwealth.
Well, wait a minute, because there are private schools and boarding schools and colleges all over this place, and it's one thing for the police themselves to determine they want to search a room. And my question to you is not, is there enough here for us to reach the question as to whether or not, if a private person who has some control, owns, leases, rents, lends, my weekend, cabin in the woods of Vermont, I lend it to somebody, and the police arrive on a tip. I mean, it seemed to me that was never really developed in this case. There are some limitations on the police that don't arise out of the fact that these are school children or what the school did here, but do arise out of what the limitations on what the state can do.
I think the analogy that the Commonwealth would try to draw for the court would be if we were in school.
No, not in school. I'm talking about outside school now.
The Commonwealth's position is still the same. Once we have a private actor who seizes the narcotics incident to their function as a private actor, as a state actor, and then surrenders that contraband to the police, the police's action is only secondary. They are merely the recipient of evidence already discovered and already seized by private actors.
Did the police ask any questions?
Yes, they did.
So if I look at the record, can I clearly distinguish between what the private actor did and what the state actor did?
Oh, the state actor, yeah, absolutely, Your Honor. More importantly, by the time the state actor arrived, not only were the four defendants already in the room or in the company of the deacon and the chaperones, the narcotics had been seized, had been separated into four different piles, which had been identified by the students previously before the state trooper arrived. And the state trooper merely started asking questions, and to the trooper's credit, he terminated his questioning once one of the parents called and said that he...
No, but what evidence, which is necessary here, was conveyed? I'm not saying that the police were not authorized to do exactly what they did. I just want to know, there is a line of cases that say the fact that you don't have a state actor initiating it doesn't automatically give you carte blanche to the state. What, if any, evidence was – where are we on a motion to dismiss here?
Motion to suppress, Your Honor.
I mean, motion to suppress. What evidence was there that was obtained from only the state actor, i.e. the police?
There's none.
None?
No.
No statements?
None at all, Your Honor.
But no,
Wait a
that's
minute,
not true.
I thought there were some statements where the trooper asked, or trooper said, you know, if you tell me who did what, then the innocent parties won't be charged. Didn't that happen?
Yes, it did happen, Your
And
Honor.
didn't he get some statements as a result of that?
There was some initial dialogue, but there was cut off when one of the parents called and said, please do not question these individuals.
One of the defendants was taken aside, given Miranda warnings, began to make a statement.
Yes.
Then in comes the phone call.
That's correct, Your Honor.
Okay, so the only involvement of the state is
Minimal,
properly Mirandized
yeah.
interrogation, brief interrogation that is suspended when an attorney calls.
Correct. It's Commonwealth's position that if the court finds that the evidence that the contraband was illegally seized by the chaperones, then the rest will be fruit of the poisonous tree.
Right. Okay.
We do not contest that. I see my time is up. Unless the court has further questions, I'll rest upon my brief.
Thank you, Mr. Perry.
Thank you very much, Your Honors.
Ms. Knight?
Good morning. May it
Well,
please-
how do you get around the state action issue? This is an entirely private parochial school.
With all due respect, Your Honor, I suggest that it is not. If I could direct you to the Record Appendix 78 on the drug and alcohol policy of the school, and I'll just read the relevant portion, which says,
But how does it make, how does
That
that
doesn't make it-
statement make it a state actor?
That doesn't make it a state actor. That just says...
It's simply, it says that illegal chemicals and drugs will be seized by the school officials, and the law enforcement will be notified. That is in the
That
handbook.
doesn't make it a state actor.
I say respectfully that in that context, the school officials are acting as agents for the state. And I'd ask you to consider the fact that there's a compelling policy, there's a compelling reason to allow for constitutional rights to be equal.
How are they acting as agents for the state? There aren't supposed to be narcotics on the property.
They are certainly allowed to seize the narcotics on the property and do away with them for disciplinary reasons, and that would not be a state action. But once when they seize narcotics or contraband for the purposes of criminal prosecution, that turns their action into state.
No, the state didn't
no.
ask them to do that, didn't solicit them to do that, did it?
So
There's no basis, however, to allow these, the private school teachers in this case, accepting that it's a private school, to not honor some degree of respect of privacy of the students.
Well, what if the child were homeschooled? And does the mother or the father's decision to turn the child over to the police subject the mother or the father to constitutional scrutiny?
In this case, respectfully, Justice Venus, I would say perhaps it would, but in this case, the Commonwealth is relying on in locus parentis doctrine, which assumes that the teachers are acting in the best interest of the child.
But the point here is...
necessarily, in this particular case...
The point here is the Commonwealth may be too generous in even thinking about that. If there's no state action, then you're sunk.
I don't, Your Honor, respectfully, I don't think that we are sunk, because if you look at the in locus parentis doctrine, it is fatally flawed for a number of reasons. But before I even get there, you'll see that clearly the search was unreasonable. That's not disputed. This was a hotel room on a ski trip that was privately paid for, and there is an expectation of privacy there to suggest that
If their parents
private
came in, for all of how, I don't know how many students there were in the room, 4, I think, and if the 4 parents came, are you telling me those students would have an expectation of privacy against their parents who were paying for the room?
But their parents would not turn the evidence over to the police.
Don't know that. They well might. What else are they going to do with
That's the
it?
difference, though, because the whole idea of giving teachers this extra cloak is that they will be acting on behalf of the student, and they don't. They're antagonistic to the searched student in an effort to protect the school. That
Now,
turns
hold
them
on
into
one second.
state actors.
Can I just ask you this question? Did the Commonwealth argue before the judge in the district court that there was no state action, or did they argue only that under the doctrine of in loco parentis they were permitted to do what they did?
I believe that they made both arguments below. And
Okay, so
I
the
believe-
judge, because I didn't see the judge telling me what the judge concluded was the state action, or am I missing something in this?
No, I don't think you are, Your Honor. What the judge did is look to the New York court and relied on Haskins, which clearly states that there's no rationale to make a distinction between constitutional rights that exist for public schools.
I understand
versus
that.
Private schools.
So am I correct that the judge did not tell me that there was state action?
The judge makes a determination that the analysis is instead whether or not the action was reasonable, and that makes the most sense here in the Commonwealth, to have a consistency between teachers that are in the public school versus the private school. Constitutional rights don't turn on and off depending on which school a student attends.
They turn on and off all the time if you don't have state action. We've got tons of cases on that.
May I move on to the next thing? There's no question that when the police do something, they are acting as agents of the state, correct?
Correct.
What can you point to that happened at the motion to suppress that says this piece of state action, i.e., after they were called, violates some constitutional rule?
What happened at the motion to suppress, when the teachers searched the room, which I suggest, but once they called the police,
yes,
they are now acting as agents for the police.
No.
And
they're not acting as agents for the police. Focus only on the police. Miranda warnings were given, correct?
Yes.
As I remember the record, and maybe I'm wrong, there was some colloquy before the Miranda warning was given, correct or incorrect?
That's correct. But that's with respect to Mr. Tripp. I represent Considine and Rogers, but I can answer that question.
Okay.
But in addition, as Justice Cordy pointed out, all of the contraband was laid out in the hotel room. The trooper correctly said to the school teacher, Ms. Rukinis, I need a search warrant before I can get into that room. And she said, oh, no, you don't. Our standard is less. We're only held to reasonable suspicion, which is what the teacher said to the trooper. And therefore, he didn't abide by the constitutional restrictions that still applied to him, stepped into that room without consent of Considine, Rogers, or Tripp.
What did he gain as a result? What did he gain that he wasn't already going to have?
He wasn't going to have it at all, because as soon as he walked in the door, that's what he saw was the evidence that had been seized. It would be a different case if they'd taken the evidence out of the room. Maybe it might be a harder case to argue with respect to the second issue.
Doesn't it at that point truly become inevitable? Surely these chaperones and teachers are not going to hand the contraband back to the 4 students, nor are they going to hold it themselves. They are going to hand it over to the police.
But the fact that they found contraband in the room doesn't justify the actions there, retroactively. So the fact that the trooper still has constitution.
I'm talking about in terms of the trooper and the state action element that the trooper's presence now brings to it. It seems to me of no consequence whether they physically hand the contraband to him in the room or whether they make him wait in the hall and go in and get it and bring it out to him. It's in the control by that time of the deacon, the chaperones, etc. And it's very clear that they have called the police and that they intend to give this contraband and whatever information they have about it to the police.
It is not an inevitable discovery argument in this case, because the police officer still had to get a search warrant to enter that room.
Oh, wait a minute.
Then at that time,
wait a minute.
the issue of consent comes in and whether it was expressed or not.
You are concluding something. What argument did your client make to the district court judge that the police, the state actors, forget about the school, that the police needed a search warrant? What, if any, arguments did you make?
The arguments I made below, as did my brother on behalf of his client, that at the time that once the trooper is involved, there must be he had to get the consent of the individuals in the room.
Why?
Well, Mr. Considine, for one, was 18 years old. Additionally, it was a private room paid by their parents, and there was no authorization from the parents that the room could be searched. And the trooper can't then assume the cloak of a teacher.
On what cases did you rely? To say straight hotel cases?
Yes, the same cases that I cited in my brief, and also, and with respect to, and very clearly that there was no express consent. In fact, the boys didn't consent. They were upset. And Considine himself said, "This is illegal. You can't be in our room."
To what extent have you found any authority that says that unlike an adult, not a child enrolled in a school, that where the school is in fact exercising significant dominion not only over the child, but over the child's access to and use of a hotel room, that from the state actor's point of view, the state nevertheless needs a search warrant, as opposed to, boarding house, I can say you can go into that room, whatever.
I would refer, Your Honor, to, I did find support in the Haskins case, which I cited in New York, People versus Haskins, cited in my brief. I also found a very compelling case.
Was that a hotel case? Was Haskins a hotel case?
It was a dorm room in Elmira College, which is a private college, and the New York court held that it didn't matter whether it was private or public, that the constitutional rights of the individual remained the same, whether or not they attended a private or public school. And that's the most compelling issue.
But that's a different issue.
It is, and if I may just give you another site, in California, a great discussion about this very issue, Gordon versus Santos School at 162 Cal Ave 530. It's a 1984 very thorough discussion as to the difference between private versus public rights.
It seemed to me that you've got a slightly different thing, because I don't know whether or not the Haskins case, the school had told its students, we reserve the right to go into your room at any time.
There had been a policy. In fact, the dean had a pass key, which is how he got into the dorm room to begin with. No trooper or any police officer was involved in that search. He went into the room with a pass key. He opened the door. He saw a marijuana plant. Then called the police in. Identical to this case, frankly. And in that case, the New York court said clearly there's no rationale to make a distinction between private and public schools when it comes to constitutional rights, particularly in a high school situation where there is a compulsory attendance and a mandated attendance with respect to in the Commonwealth. So it's even more compelling at a high school level than it would be at a college level. But in the New York case, it was in a college level.
Thank you, Ms. Knight.
Thank you very much.
Mr. Miliotis.
Actually, I've got reserved, if Your Honor, please, this issue, this dichotomy. I think state action is a tough barrier to the defendants in this particular case. However, I think we've got a merger here of something that I might call school action. In respect to when you have this closeness of a relationship with law enforcement, we can use some of the classic principles that we've used in distinguishing whether the use of probable cause or reasonable suspicion. We have carved out, by avoiding warrants, the requirement for warrants in the school, we have carved out that reasonable suspicion in situations that would normally require probable cause. So we have protected schools. The question is whether parochial schools should have any application at all.
But right in the policy, or whatever it is, of the school, it says we're going to search your lockers. So if they're going to search lockers that are closed with keys, why can't they search hotel rooms that are closed with keys?
Whether you establish it on a reasonable, I think we'll base that on a classic reasonable expectation of privacy. And in some respects, there's a greater expectation of privacy in this situation.
Absolutely not. There's a far greater expectation of privacy in a 20-year-old than there is in a 17-year-old who's a high school student.
I'm talking about locker versus a hotel room.
Oh, I see.
There's a greater expectation of privacy, I suggest, in the hotel room, and I suspect both on the issues that Justice Greene and Justice Cordy had raised initially in your concerns, Chief Justice, about this line that may be drawn in respect to why wasn't a warrant required in this situation. Now, if you adopt the concept that they can seize things and keep them, despite the parents coming to the room, like what happened in this case, the call was made, stop the interrogation of the children, intercession by parents. There's not an automatic belief that parents are going to turn over these drugs. If parents got there, opened the door, went in there, took the stuff, put it in a briefcase, and left, who was going to stop them?
Mr. Miliotis,
police.
let me ask this.
The police, if they wanted
police-
to.
And then
As
if
soon
they
as they
search
find
the
out
briefcase,
about
and
it.
if they search the father's briefcase, in that situation, they'd have to at least meet standards of probable cause in exigent circumstances.
Well, yes,
perhaps.
but
Can I ask you this
the
question?
chaperone's
Yes,
telling them
yes.
that that's what's in there. It
I'm sorry?
would meet it.
But that doesn't, everybody tells somebody. Nielsen case, they were told there's marijuana, I believe, and that was a similar situation, more similar than anything else. Why not get a warrant?
So is it
Miliotis,
your
can I just
position?
ask the question that I was trying to ask? Did you argue that the school had no right to go into the room?
Yes.
You did?
Yes. And initially, frankly, the government only came in at the last minute and raised the state action issue. They were arguing reasonable basis. They said there's a reasonable basis.
But they
Really,
did raise it.
ultimately, yes. And so we were arguing on a stand, on a very, whether it be Damien D., we argued very forthrightly, and I think the judge probably could have gone the one step further, but preempted the analysis. All the evidence, all the facts were there for the analysis to determine that this, in fact, was state action. It started with the Cheshire police officer, because the Cheshire police officer, who was the security person, was the one that gathered up and piled up these things and got everybody to acknowledge which was there. Now, if you're going to say that's seizure, then why isn't that state action? If you're going to say the parents couldn't come in and flush the stuff down the toilet.
Let me stop you there. So anything before the security person, who was the part-time police officer, that was not, would you say that was not state action?
I'm concerned about that, and I'm concerned about that the court will, as a blank, say, okay, it's not state action, we're okay here. I think
But
that
you
it is,
start
I
from-
think that I start from the point where the contemplation is the rule appropriate, that's in the handbook. Appropriate law enforcement officials will be notified by school administrators. As soon as you start that process, now I think you're permitted, despite upholding state action premises, that at that point in time, when the school officials start following up, not just because it's written there, but start acting, that appropriate law enforcement officials will be notified by school officials, which is in the handbook. Once they start that process, now I think you can do a mechanism. You can make a rule about school action at that point in time that contemplates traditional values as to whether the police can ultimately get the evidence. And you can establish standards for schools that say, we're going to do it, but not only just say it, do it. And then it can be a fact-by-fact analysis, similar to the problems we have with Crawford. We've got to look at each case. This can then, rather than be a broad sweep, there is no state action in parochial school law enforcement activities by private parties, but at a certain point in time, school action, school law enforcement action, these schools now adopt a role in traditional state support of the criminal laws.
You said that there was a Cheshire police officer involved in the sorting of the drugs?
Yes.
Was he in uniform at the time?
He was functioning as the supervisor of the facility, was a Cheshire part-time officer with
Of the hotel.
of the hotel
So
with
he was
arrest. Is it my understanding of standards with arrest powers similar to Commonwealth versus Leone?
I have two questions for you.
Please.
First, is it your position that we should have the same standard for private and public schools?
I think there's going to be trouble from the initial trouble because of state action with doing that. I think that you can apply requirements similar to you got to have a reasonable basis to go into a locker. Once you're contemplating involving law enforcement, once your role is in the enforcement of the laws, and you get to that next step, how do you know it? You maybe have to do it on a case-by-case basis. You maybe want to say that because there was an arrest, because police were involved. In this particular case, everything pointed to the fact that this was all one step along a process of getting the police involved. And I feel very strongly that there is no excuse for not getting a warrant here. But that's only a factor in whether or not school officials should, in private schools, at a certain point in time, yes, they do. And I think you can fashion a standard. You've done it with interrogations. You've done it with lessening the standard to reasonable suspicion. And I think that at a certain point in time, you can say, what are the factors? What's the purpose? What led to the arrest? At what point in time did they start enforcing this handbook that says we shall involve law enforcement if you do this activity?
So in this case, if all that had happened was that the chaperones and the deacon had confiscated the items, didn't contact the police, you wouldn't have any complaint with their search?
I think that there's a good reason that the court has good cause, without state action, to make that finding. That could be the line.
Mr. Miliotis, am I correct in understanding from your answer to Justice Ireland that if, rather than calling the police, the teachers had taken what they had obtained and walked down to the police office, either there or back in Boston, and said, this is what we found, we want you to prosecute, you think that is not permissible for a private school?
Well, I can't concede, because we still maintain that there's enough ties to the parochial school for this court to find state action. But if you use traditional standards of private action, unless there was coercion, there might have been coercion in this, there might have been some unusual circumstances. If the teachers just said, or if it was on the ski slope, and there wasn't a reasonable expectation of privacy in that. But once you get it out of the reasonable expectation of privacy environment, and they have access and use of it, and they call the police in the silver platter type doctrine.
Well, let me make sure that I understand. For these purposes, assume that the children had control over the room, like they do over their locker, assume. And that they know that the teachers can go in. And they find contraband, illegal contraband. And the teacher hands that to the principal, and the principal calls the local police and hands it over to the local police. You're telling me...
Okay, now I get it. All right, that point in time where I would still suggest that the court, in terms of school officials, where there is some element of compulsion by the state, some element that they have control over, there would be still a standard line at which time that would evaluate the purpose, the timing of which the police were involved, and if in fact the police did get involved. I think you'd still be able to draw that line even though they get out of the room and they have custody. I think that's consistent with my argument now. The court, we don't have a doctrine now. I think there needs to be a doctrine that protects particularly vulnerable minors against intrusions that could be in the nature of constitutional rights, or it's certainly violation of privacy. I think we need some standard to apply to this situation, or we could just leap and say the police couldn't go in there because they didn't have warrants.
Let me ask you one last question, hypothetically. No field trip, just in schools. Do you agree with your brother who told me that in the private school they could search for any reason without any suspicion or anything? Just
I think we need a standard.
like
that scares me to say that that's true, and I think that's what I'm inviting the court
so
to
you
do.
don't
If
agree?
you don't find state action, that you've got to create, at least there has to be some limitations upon that standard. We need to incorporate something that protects these children in schools against arbitrary action.
In other words, the students will be running the schools.
Sometimes it's the best thing in certain circumstances, frankly. I think we did that in the 60s. And Amherst College was perfectly happy to let us run it. Matter of fact, they invited us to run it, it seems.
You should have come to Holy Cross. It was entirely different.
I wasn't tall enough to play basketball there,
Thank you.
Your Honor. But they did have great rugby.
Thank you, Mr. Miliotis. We'll take a
Thank you
short
very
break.
much for your consideration.
All right.